Governor, your take on the federal mask ban, the ruling by the judge. If I get your take on the judge called out the state carve-out for state police in this bill. Who asked for that carve-out, and was it the wrong move?
Well, the bottom line is we're disappointed in the decision. I don't believe that federal agents should be running roughshod over the Constitution, putting communities that are already on edge in more terror and more distress by having masks on. No other law enforcement agency operates like this, period, full stop. It's about trust, and it's about relationships. And they're destroying trusts, and they've frayed relationships, not just nerves. As it relates to amendments, we offered the author the amendments that were reflected in the bill that was upheld. Those amendments were not taken by the author. We believed it should have been a federal masking bill, period. We're pleased as it relates to the second decision, as it relates to the ID bill, and appreciate the Attorney General's strong advocacy on both. That was upheld, and that's quite significant. California's led in this space, and will continue, as the AG can, I imagine, attest, we'll continue our advocacy to move this process forward as well. And I don't know if you want to, this is if I may, because point of personal privilege, because he's been such a strong advocate on the masking bill. Mr. Attorney General, want to add anything to that?
Yeah, thank you. Of course, my office has the duty and obligation that we take very seriously to defend in court the laws of the state of California when they are challenged, and we defended both laws in court. We're there, of course, for the hearing. We argued it, and the final ruling was consistent with what we expected from some of the clues left by the judge in the hearing. And I think what's most important is what the governor was saying, is that if you can't tell the difference between a criminal trying to harm you and a law enforcement agent who is masked and you don't know who they are and they're being aggressive and they seem to be threatening you, you have a huge problem. And accountability and transparency are critical. The masking policy of the federal government at this time does not meet those standards. It undermines trust, and it's a major problem. It's a public safety problem. And so the court upheld the bill, at least for now, in terms of not granting a preliminary injunction brought by the federal government on the ID portions, requirement of a badge number or a name, a department. That's fully upheld for now. We'll see. The case continues, of course, but a preliminary injunction asks, are you likely to succeed on the merits? And the federal government was denied when that question was asked. And as to the masking portion, the judge made very clear what a pathway might look like if this is something that California decides to pursue. And of course, when you have the federal government interacting with the state, there are things that are appropriate under the law to consider, the Supremacy Clause, the Intergovernmental Immunities Clause among them, which were considered by this judge in this ruling. But I think there's a path forward if it is sought, and we will continue to do everything in our power to defend the laws of the state of California when they are challenged in court.
And if I can just say one additional point on this, I'm very proud of this legislature. I was very proud to sign that bill. It was the first in the nation masking bill. And I'm hopeful that Congress will take the leadership role and do the same. I'm very grateful to the leadership, both the House and the Senate, at least the Democratic caucuses, for their willingness to make this a priority moving forward as it relates to any additional funding for DHS. And I think that's a principled stand, and it's one we strongly advocate.